As more litigants find financial support from third-party investors, calls for the regulation of litigation financing are increasing. In the past few months, Vermont and Indiana have joined several other states in regulating the business of advancing cash to plaintiffs in personal injury litigation. These regulations include notice and disclosure requirements, standardized contract language, and bans on attorney referral fees. They are designed to make sure that such financial advances are made fairly and without deceiving consumers. Litigation funding companies support this kind of regulation. The Alliance for Responsible Consumer Legal Funding, a trade group including many of the established legal funding companies, expressed support for these new rules, describing them as consumer protections. They believe these rules will help promote standard, legitimate business practices that will make litigation funding more successful and more widely accepted. This kind of regulation differs from what has been enacted in other states, most recently in Arkansas and Tennessee. In these states, statutes have been passed to treat litigation funding like an ordinary loan, making it subject to interest rate limits. But litigation funding is not a loan. It is really an investment. The funder is not assured of repayment and puts its investment at risk if the party receiving funding does not eventually receive an award. Everyone wants to help consumers, but the best way to help them is not to prevent them from making decisions about how to protect their rights. They are best protected by rules that help them understand their transactions and make rational choices about what justice is worth to them. If you need help with litigation funding, call or email me today.